Thank you. Welcome to the Court of Appeals this morning. We have 4 cases scheduled for consideration today, and in 2 of those we have oral arguments scheduled. And the first of those is Winn versus McKinlay. If we could have counsel enter their appearances, please.
Todd Walquist for the appellants.
Thank you.
Eric Nielsen for the appellants.
Thank you.
Troy Boer for the appellee.
Thank you. Looks like you're reserving 5 minutes for rebuttal. Unless you have questions before we begin, we'll just go ahead and hear your argument.
Thank you. May it please the court, counsel. In 2023, Gallup did a poll. They asked people to rate the different professions and whether or not they thought they had high ethical standards or were honest. 16% found that believed that attorneys had high ethical standards or were honest. We beat insurance salesmen, car salesmen, congressmen, and senators. I actually Googled how many lawyer jokes are there. I didn't know, but that was its own joke. The answer was 3. The rest are all true stories. Just last week, this court issued a decision finding that, and you talked about the societal phenomenon of attorney misconduct. And now it's under some circumstances it's foreseeable that an attorney is going to act dishonestly. Unfortunately, this case gives more fodder for the narrative that attorneys will do whatever it takes to win, even if that means breaking the rules. If the court will give me 30 seconds, I want to run down some facts of the case, not because you don't know them, but because they're relevant to the argument that I'm going to make. Holly Winn was getting ready for surgery. She went to her pulmonologist because she was scared that she'd get a pulmonary embolism. That pulmonologist wrote a recommendation. Here's the recipe to avoid what you're afraid of. The doctor that wrote that and Mrs. Winn gave that to Dr. McKinlay's office. Unfortunately, after the surgery, he did not follow that recipe. He didn't do what the pulmonologist recommended. Holly Winn, her worst nightmares came true. She got a pulmonary embolism and suffered a brain injury. When Dr. McKinlay was asked, why didn't you follow that recommendation? His answer was unequivocal and repeated, I didn't see it. When asked why he didn't see it.
Can I jump in? I've read the briefs and I'm familiar with the facts. Here's what I'm wondering from your side on the legal issues that we've been presented with. The thrust of your argument, as I understand it, is that you were ambushed by the change in testimony at trial. Do I have that right?
Yes.
Okay. And do I have
I'm sorry. Not just the change in testimony, but the change in the facts.
Change in facts, right? The change in the factual picture presented by the other side. As I understand it from the briefing, the first time you really learned about this was on day 2 of trial, when Dr. McKinlay first suggested he may indeed have seen this. Do I have that right?
That was actually day 1. I believe.
Day 1 of trial. Okay. This is coming before us in the context of a Rule 59 motion. That's the thing that seems to be before us on appeal. So even if it's true that you didn't have any prior notice of that, and even if it's characterizable as an ambush, it feels like at that point you still have a lot of leeway to try to ask the court for various remedies. This is a multi-day trial. It's a 12-day trial. So what the other side is telling us is that if you had wanted to request a mistrial during trial, you had a lot of time to do so. So the fact that you didn't request a mistrial during the trial gives support for the district court's decision not to grant a Rule 59 relief after trial. What's your response to that?
I would say that the prejudice should not be evaluated by how we respond to it.
I'm not even sure that necessarily goes to prejudice, because the first component of the Rule 59 inquiry is whether there's an irregularity in the trial that deprives one side of a fair trial. And so I think the pitch from the other side is, look, even if you were surprised on day 1, and even if you really didn't know coming into trial that this change in factual presentation is going to happen, you then get to make a choice as to whether you're going to request a mistrial at that moment or whether you're going to play this out and see what the jury does anyway. And that once you make that choice, then there's no longer a fair trial deprivation. I think that's their argument. Why are they wrong about that?
Because again, I think it judges the whole thing based on how Mrs. Winn responded to the ambush. For 4 years, everyone had been litigating with this particular set of facts. All the witnesses, the experts were prepared on this set of facts. And then on day 1, after all that preparation, everyone is there. hundreds of thousands of dollars spent to be in that moment, then there's a new set of facts presented. That the ambush occurred, and the fact that
But
Mrs. Winn,
isn't that all the more reason at that moment to then go to the judge, if not day one, day two, or day three, and say, they've completely changed the factual picture, we need a mistrial so that we can properly counter that?
I feel fairly confident in saying that if I asked a trial judge, we have a change in testimony, we want these different remedies, strike it. The judge would say, Mr. Walquist, you have the deposition, go impeach the witness. We want a mistrial. A mistrial is a huge endeavor. I suspect the court would most likely say, you have the deposition testimony, impeach them. That's your remedy, which is what we tried to do.
But when we're second guessing what the trial court did with the post-trial motion, one of the things we have to consider, I assume, is looking at the flip side of it, of whether there would be strategic reasons. Here you are in trial, where your witness is sitting on the stand and has to admit all of these ambush facts. And I think you established it in the cross-examination, that you've now completely changed your story. You cast aspersion effectively, I thought, on the motivation for that. You know, all of a sudden in your closing, I think it was, you tied it all together. Look, this theory, there's been a realization that this theory is a bad one, because not only do you have your own liability, but you have the liability for the entity that supposedly misfiled this. So now you're changing your story to say, no, I probably did see this thing. Excuse me. So you're in this moment where there's a lot of reasons, it appears to me, to not seek all the remedies we just talked about, because things are going bad trial-wise for the defendant. It kind of looks like maybe he's not telling the truth. All of these different reasons not to seek a remedy. And if that's true, understanding that you're ambushed, I'm assuming for the purpose of my question that you've been totally ambushed, but you've turned that ambush into, you've made lemonade out of the lemon. Why should then post-trial, when the verdict doesn't turn out, why do we all of a sudden step back and go, oh, no, we got to give you a remedy for this ambush, when you made it appear there's at least a reasonable argument that a strategic decision was made not to seek all those remedies? Why is that wrong?
Because I think it places, again, too much emphasis on the response, on how Mrs. Winn responded. She could have done things differently. We would have been asking entirely different questions at trial. This would have been an informed consent trial. We would have had other witnesses to talk about Dr. McKinlay's testimony. The fact that, and I don't think we can undervalue the difference between a calculated ambush and being in the heat of the moment in a trial and having
The biggest place where I have difficulty with your argument on that is with that we would have changed to informed consent. As I understand it, the trial ended in November. The written judgment came in March of the next year, and you had 28 days to file the new trial motion. So from November to April, you're no longer 5-6 months later in the heat of the moment. Even in the new trial motion, the idea of the informed consent changing to that tack was not raised. And we have some preservation rules that would preclude us from addressing that argument unless we create a new preservation rule. Isn't that correct?
Well, I guess I disagree that the preservation rule prevents the court from addressing it. The preservation rule is one of prudence, not jurisdiction. So I think that the court can address it. But the other thing is the trial court, so we raised the issue of the unfair trial in our Rule 59 motion. And the trial court addressed that. And the trial court specifically noted that if that disclosure had been made timely, there's other things that the plaintiffs could have done pre-trial. And so the court evaluated pre-trial motions, additional discovery, things like that. So the court considered that we could have done things differently prior to the trial. So I don't think we have to enumerate all the specific ways we could have done something different. The trial court clearly considered those. I think that the trial court got it wrong.
The trial court didn't consider, though, an informed consent.
Correct.
And while preservation is a rule of prudence for the judiciary, we're not the top court of the state, and our Supreme Court has outlined kind of our rule, the rules we need to play by in terms of preservation.
Right.
And I don't know that we are at liberty to create new rules.
Well, I think, so that the court has said that attorney misconduct can be the basis for granting a new trial. And in this case, we believe that because this ambush was orchestrated by counsel, that is sufficient grounds, an exceptional circumstance to grant a new trial.
Did you argue exceptional circumstance in your primary brief?
We did not.
Then aren't you precluded just by all precedent from raising it at all at this point?
So,
If you don't raise, we have a myriad of cases that say if you don't raise a exception to preservation in your primary brief, you've waived it. The end.
okay.
Don't we?
So yes. But I do believe that again, that we did cite that attorney misconduct can be grounds for
That's
granting a
not,
new
my
trial.
point is if you're gonna claim an exception to preservation, specifically exceptional circumstances, you have to do it in your primary brief.
Okay,
or it's
agreed.
waived. Okay. The other thing is can you, I guess back up. Do you have a case where exceptional circumstances has been applied? And while you're thinking about that, if you do, is it a criminal case or a civil case?
I feel safe in saying that most of the exceptional circumstances that there are would be criminal cases. Here's my response
And
to.
my last question is, we have cases that say there's a difference on these preservation rules between criminal cases and civil cases. For example, plain error is not applicable in civil cases, right?
Correct.
Is exceptional circumstances applicable in civil cases?
So whether or not the court has framed it as an exceptional circumstance, I don't know. But the court has said in civil cases, that again, that attorney misconduct can be the basis for granting a new trial. And where that fits into the preservation, again, I think goes back to it's one of prudence, not jurisdiction. This court could consider it. Implicit in the preservation argument is that it would be patently unfair to opposing counsel to raise an argument for the first time. Holly Winn showed up at trial after 4 years of litigation, prepared to go to trial on a particular set of facts. It was unfair for Dr. McKinlay to pull the rug out and completely change the dynamics of that trial. It made everything that she'd prepared for meaningless. Her allegations in her complaint, her expert witnesses, all gone. That was unfair. So this idea that preservation, we're now being treated unfairly on appeal because we didn't get to hear these arguments beforehand. Holly Winn deserved a fair trial.
I know you're at zeros, but I'm wondering if I could just ask you a fairly brief question about the second issue that's been raised on appeal, which has to do with the testimony from your witness that there had been 2 prior deaths from Dr. McKinlay relating to pulmonary embolisms. One of the things that they're telling us in response is that you did not ask to put on any more of this evidence than what had already been put on, and that's reason to deny your argument there. I'm wondering what your response to that is. First of all, did you actually ask the court for leave to put on any additional evidence?
We did not, because when we were arguing about, we had argued that the door had been opened.
So what's the error that we'd be reviewing? If the district court didn't strike the evidence that the jury did hear about the 2 prior deaths, and if it's true that you didn't ask for leave to put on additional evidence, what would we say was the error that warrants a reversal on that front?
So in the context of their motion for mistrial, we argued that the door had been opened and that we should be allowed to present that evidence. What we didn't do is later on, after the court said, no, I'm not saying that the door is open,
So what's the error that we'd be correcting on that issue?
that the door was not opened. We argued that the door had been opened and that we should be allowed, because Dr.
But if you didn't ask to put on additional evidence, and if the district court didn't strike the evidence that the jury heard, what's the error that we're correcting?
So again, I think in the context of that discussion with the court, where we argued that the door had been open, we should be allowed to present evidence on that. Did we, after the judge said, no, the door isn't open, no, we did not go back and say,
So you're
We
saying
wanna
that
put on-
if the judge had said, oh, the door was open, then you would have put on more evidence?
absolutely.
But isn't there a precondition for that argument to work? Don't you need to have said to the judge, we've got more evidence that we want to put on? So that she then says, no, you can't? I mean, without that sequencing, how do we get there?
Well, yeah, again, I think because in the context of that conversation, we had clearly argued that the door had been open, and she said, no, it hadn't. And so,
So you're making something of a futility argument, if I'm understanding it right. You're saying we didn't have to ask for leave to put on more evidence because she'd already said she wouldn't allow it.
right, and I think we should be allowed to presume that that ruling was going to stand, and we shouldn't challenge it later just for, we told her we wanted to, and she denied that.
And later, she indicated that in context, she wasn't saying that it wasn't open in a global sense, but that, I forget the name of the, Dr. Miller? No. Who was the doctor?
Williams.
Dr. Williams, that it hadn't been opened for plaintiffs to pursue that line of questioning with Dr. Williams. Because Dr. Williams had, of his own accord, said, given that testimony, and the defense hadn't led him into it, and so the judge ruled the door isn't open for the plaintiffs to pursue this line of questioning with Dr. Williams. Now, she didn't say with Dr. Williams, but the context seemed to indicate that, and the judge later said, that's what I meant. I wasn't saying it was closed in a global sense.
Right.
How do we respond to that?
Well, I think that after the fact, that's what she said, that's not what I meant, but in that moment, that is clearly how we took it. We said, Your Honor, the door's open. She said, no, it's not. And so we relied on that and not pursuing. I understand later she's saying, and I'm not saying that may be what she was thinking, but there was no way for us to have known that. We said the door's open. She said, no, it's not. So we stopped.
I'd like, unless you've got to follow up on that, I'd like to take you back to the other point, and I know you're at zeros, but you've mentioned attorney misconduct being a basis for a new trial, and the trial court, I believe, essentially found that there was attorney misconduct. I'm troubled by the conduct, but the law that you cite to us says that attorney misconduct warranting a new trial must be real and substantial, and such as may reasonably be supposed would affect the result. I read your brief as asking us to do away with that second half of that sentence, that if we've got real and substantial attorney misconduct, that you'd like us not to evaluate whether it affected the result of the trial, that just ought to per se be grounds for a new trial. Is that what you're asking?
So I'm not sure that would be an unreasonable rule, but that's not necessarily what we're asking. Because I think, even in this case, because I don't think we have to get there, because even in this case, I think we can reasonably assume that changed the outcome of the case. Because, again, we went to trial prepared for one set of facts. And when that changes, there's just no way to estimate. I mean, this is the butterfly effect.
But,
right?
but when the jury finds that the clinic breached the standard of care, I mean, the natural reading of that, I think, and feel free to push back if I'm reading this incorrectly, but the natural reading seems to be that the jury thought that the letter from Dr. Bird had been misfiled, the report from Dr. Bird had been misfiled, which seems to suggest that the jury rejected this sort of changed approach that Dr. McKinlay took at trial.
Yeah,
so where's the prejudice?
Well, because what Dr. McKinlay also said was that when he said, I would have read this and exercised my clinical judgment, the jury may have said, well, okay, we think the clinic misfiled it. But based on what Dr. McKinlay said, even if he had read it, he wouldn't have followed it because he didn't think he needed to give anticoagulants. And so, which was a change in testimony, because in his deposition he said, if I had read it, I would have called Dr. Bird and talked about it. And now he's saying at trial, well, I wouldn't have followed it anyway. So the jury was influenced by the change in testimony.
Anything further? Thank
I
you.
think there was an unanswered question, with Your Honor. But
You got mine answered.
Okay.
Thank you.
Thanks.
And you've got your full rebuttal because we kept you over.
Thank you, Your Honor. May it please the court. There's a reason that we moved for a mistrial, even though it was denied, and it's because the cross-examination was pretty devastating and things weren't going well. And there's a reason that the trial court or trial judge after trial and adjudicating the Rule 59 motions specifically noted that it appears that plaintiff's counsel is very experienced and successful, believed that the damage to the credibility to Mr. McKinlay outweighed any irregularity and surprise. And the trial court says, and from the court's vantage point, this was a sound trial strategy. So the trial court found that it was a strategic decision. And I want to point out that the Larrabee case and the Fullerton case that deal with the change from the old law, which was if the trial court in a post-trial motion addresses an unpreserved issue, it's preserved for appeal.
And
That's what
both
they're
of those
arguing.
are state cases, or, I'm sorry, criminal cases.
They are criminal cases. And there was never even a civil case with that first ruling that they got rid of in Larrabee, Your Honor. And so it was always in the criminal realm where that was being articulated.
But we do have civil cases where an issue, the trial court takes up an issue in a post-trial motion. The trial court has discretion whether to even take up the issue. But then once the trial court takes up the issue, makes a legal ruling on it, then that's preserved for our review. We have a number of cases saying that, don't we?
It can be under certain circumstances, but I also don't read Fullerton and Larrabee to be confined to the criminal setting. And it's notable that both of those cases also involved attorney misconduct. And the Supreme Court is saying, here's what you don't get to do. You don't get to say something bad has happened at trial, but I think I might win. And I want to find out whether I'm going to win or lose before I say that this trial isn't fair to the point that we need a new jury.
And
And
I think
that's
this
what
is
happened.
I think this is inherent in your framing just there, but in terms of the various pieces of Rule 59, does this go to the irregularity prong? Does it go to the fair trial prong? Or does it go to the prejudice prong, what you're saying?
It clearly goes to the prejudice prong. It goes to the irregularity and surprise prong to the extent that the test sort of melds
Right.
the two. Certainly the trial court pulled them apart, but it would go to the prejudice prong within there anyway. So I don't know that it makes a difference as to the court's analysis. I mean, analytically, I see that it makes some difference, but I don't think it matters too much. I mean, this trial court was pretty clear, and it makes perfect sense. I mean, there's a sense in which our case got worse with the change, because now we've got a cause of action for misfiling, and we've got someone saying, if I must have seen this, and if I did, I disregarded it, and was impeached by prior testimony that I would have called Dr. Bird to figure out what's going on. But to put the court's mind at ease, and the reason I think why the trial court is saying this doesn't matter, and she actually put this in her order. If you go to the closing arguments, towards the end of the closing arguments for the defendants, what they say is, this Dr. Bird note is a red herring. And the reason it's a red herring is Dr. Bird testified that his note doesn't go to the standard of care. He's a pulmonologist, and he said surgeons have bigger issues on their plate. He can take it into consideration, but the standard of care is not set by my note.
But I think what they're telling us is that was sort of a reactive response in real time, that they didn't have the benefit of months and years of preparation, and that if they had months and years of advance warning, as they were entitled to, they may well have taken an entirely different tack.
They may have, but they didn't articulate it to the trial court as to what it would be. And that was the defendant's closing argument that was saying.
But why isn't it natural to assume that they would have raised an informed consent claim? I mean, that has some resonance with me, because it does feel like the natural response to this shift in testimony. The moment he says, oh yeah, I would have likely read Dr. Bird's report, and I would have likely then decided to do what I did anyway. Now, if they add an informed consent claim, now they can go to the jury and say, look, he loses either way, because if he read it and disregarded it, he didn't tell us about it. But if he didn't read it, then he loses because he should have gotten it. It allows them to win in both directions if they add that claim. And it feels like the only reason they weren't able to add that claim is they didn't know about it in advance.
Yeah, I have two responses to that, and the second is the most important. First response is, if you look at the district court's order, she talks about discussions of informed consent and the defense using it as a reason why the standard of care is irrelevant, because Winn consented. But the more important point, I think, is you go back to the complaint in the case that the trial court also cites. And what's really interesting is the complaint has the theory of the case that was presented at trial. It's the deposition that changed the theory of the case. So the complaint, from the time of the complaint until trial.
But why aren't they allowed in preparing for trial more granularly? Why aren't they allowed to rely on the depositions? I mean, it seems to be the whole point of the discovery process.
Your Honor, the deposition testimony is what they're claiming dissuaded them from bringing an informed consent claim because he never saw it to be able to talk to her about it. They're claiming they would have brought an informed consent claim if they'd known all along that at
So
trial he was
you're
gonna say
saying they
he'd
should
seen
have
it.
brought this all, okay.
Yeah, but in their complaint, they think he saw it. In their complaint, they say that Dr. Bird sent it and he received it. Holly Winn gave it to him and he received it, and nonetheless, she consented. And says that she talked to McKinlay after the surgery about not getting the drugs. I mean, there's a reason they didn't bring informed consent. I'm sorry, Your Honor.
And I haven't looked at that original complaint yet. It did not plead informed consent?
Absolutely not.
But you're saying it had the facts that would support informed consent are pled, but the theory is not pled?
So their claim is, we had a theory of the case at our complaint. It was completely changed and disrupted at the deposition, and then you went back on what you said at your deposition at trial, which put us back where we were at the beginning, which is, we sent this note to you and you disregarded it. That was their theory. It also has plenty in here about how informed she was. That Ms. Winn asked Dr. McKinlay about continuing coagulation and was told that it was not necessary. That's in their complaint. So it also says at paragraph 23, Ms. Winn consented to allow him to perform the surgery, which they say on the record at trial, they don't have any quarrels with the surgery. She went home, was told if anything goes wrong, call. She called, she was sent to the emergency room. That's where Dr. Todd gets involved. Tests, she's sent home. We call her again to see how she's doing, doesn't return the call. Dr. Todd asks her to follow up, doesn't return the call. Then days later, something ends up happening. And so there's a reason why it wasn't an informed consent.
And I'm sorry to return back to what feels like a fairly esoteric question from my end, but the fact that they didn't plead an informed consent claim in the original complaint, does that go to prejudice most naturally, or does it go to the lack of a fair trial most naturally?
Well,
Or are they just simply the same thing?
it's gotta be prejudice because it can't be that this trial wasn't fair because we didn't bring a claim, and it's not the normal kind of prejudice. I mean,
So you're saying that there's no reasonable probability that the result's different, and we know that because they didn't file an informed consent claim in the first place?
and didn't ask to. I mean, and this is one where preservation is particularly important. I mean, you have to ask to amend. I don't think it's a foregone conclusion, even though they say it's undisputed in their brief. If I'm the trial judge, I think, what changed from your original complaint? Why didn't you plead informed consent earlier? It's too late for you to do it. There's a good chance that happens, but you have to get her to use her discretion to allow you to amend. Then you have to inform the jury about it. And then you have to assume, even though there's all this discussion about, we knew what was in the note, we brought it to you, we knew what was supposed to happen, we've been through this before, we had a discussion with you.
But doesn't the fact that the district court was so troubled by the change testimony that the district court goes on at some length about how she thought this was improper, doesn't that suggest that she would have exercised her discretion in this manner?
Perhaps.
She's clearly bothered by
She
this.
certainly would have done something, and she imposed a sanction that's not appealed.
Right, she opposes sanctions. She goes out of her way to say that she thought the attorneys from the other law firm, recognized, manufactured this very late shift in testimony without properly notifying the other side. So if she's that concerned about all this, and then they say to her mid-trial, look, we'd like to amend to add this new cause of action and/or, ask for continuance so that we can properly prepare for this. All of those data points do suggest that she would have been open.
I think she probably would have given him a continuance. I think she would have followed Rule 15 as to whether she would have allowed them to amend. And I think you would have gone back and looked and said, wait a minute, you've been surprised by being put back into the case that you started with.
But don't we, isn't it fairly routine that the complaint is amended to reflect the evidence that came on at trial?
I think that's right, and I think the evidence here, I mean, I just think that their reply brief, which is the first time it showed up, is just dead wrong about that. I don't think these things are undisputed at all. There was a training session before the surgery that talked about the risks. There was a lengthy discussion with Dr. McKinlay before the surgery. According to their complaint, there's a discussion afterwards about the drugs and the fact that they're not being prescribed. I mean, it's hardly clear to me that an informed consent claim would have prevailed if they'd have been allowed to bring it at all by the district court. But I do know that they didn't ask the district court for that, so we have no idea what she thinks about that. But she was very careful and detailed in explaining that I don't think it affected this jury. you seem to get an advantage. As unfair as this was, it looked like at the end of the day, you were so skillful at cross-examining and exploiting this with the jury, good for you, that the jury found a breach by the entity because you convinced them that his deposition testimony was correct. And if his deposition testimony was correct, how as a trial court can I say that it was prejudicial here? And informed consent was ballied around as being used by the defense as a way to make the standard of care irrelevant. You can see that in the trial court's ruling. She talks about that mid-trial, not the other way around. And so I just don't think on this record that the court can get there, particularly when it's unpreserved.
Just back on the Rule 59 standard, you're not contesting the finding of an irregularity based on attorney misconduct.
We haven't cross-appealed that particular issue. We didn't appeal the sanction, and, the sanction actually isn't even before the court because an amended notice of appeal was never filed. I mean, it also undermines the reply saying that, you can't let people get away with this. No one got away with anything. The judge granted the very sanction they asked for in their motion. All of it. And we're not appealing it. And so the question here is whether there was a fair trial and whether strategic choices were made. And the trial court found they were, that we think this trial's going well. Let's wait and see how it comes out. Oh, it didn't come out in our favor. Now we're going to ask for the new trial and say it was completely unfair for this jury on this record to be deciding this case. That's exactly what you don't get to do under Larrabee and Fullerton and a long line of cases. I mean, the point is, like, if you think this jury shouldn't be the one, you don't waste the court's time and the jury's time and the witness's time and everybody else's time. And you certainly don't oppose a mistrial motion by the other side if you don't affirmatively want this jury.
They've got motion-specific idiosyncratic reasons to oppose that motion and still want a different outcome on this one. I mean, they've pointed to them in their briefs. If they agree to that particular mistrial motion and then the case gets retried, there's downstream consequences based on that motion. Are they right about that?
No, they're right back to where they were in their motion in limine. I mean, it's pretty important. I mean, it's actually pretty interesting.
So you don't agree with their suggestion on that point, that if they had agreed to that mistrial motion and the case gets retried, and then there's a dispute about whether they can put on evidence of the prior deaths, that would have impaired their ability to do so?
They stipulated to the motion in limine that they can't put on evidence of prior deaths. They wrote the order that said we can only do it if the door is opened. And I want to point this out because the trial court points this out in her order at 7680. They gave 3 reasons in opposing the motion in limine as to how the door would be opened. Quote, implying defendants are widely respected, always careful, or otherwise attempt to bolster defendant's image. Those were the 3 ways they articulated as to how the door would be open and they would be able to introduce this. Otherwise, they agreed they couldn't. None of those happened, and that's not what they're arguing on appeal. So I think that order would still be in place in the next trial. It was stipulated.
Let me ask you a downstream question. It's one of the smaller points that's raised in the briefing, but I just wanted to get your reaction to it. One of the things that has come up is whether it should matter that plaintiff's counsel is experienced counsel. You brought that up in your brief to bolster your argument that this was a strategic decision. And I take the point on some level, but then I worry that if we said that in a published opinion, that it creates a little bit of a weirdness where we're drawing lines between what we think are experienced attorneys versus not, or what the district courts think. And I'm just not sure how much weight we really should put into that.
I don't think you have to put any weight on it because that isn't where the district court's analysis ended. I mean, she certainly said that.
Yeah.
She said you're very experienced and successful. You seem to believe, you could say this part without being experienced, you seem to believe that the damage to his credibility outweighed any irregularity or surprise. And then her next sentence, and from the court's vantage point, this was a sound trial strategy. So even if it was a brand new lawyer,
Right.
it's still a sound trial strategy, and your deliberate choice not to want to get rid of this jury because of the surprise and you don't feel like you can present your case effectively to them.
In other words, as long as the evidence suggests that it was a strategic choice, then the court objectively is analyzing whether it was a reasonable one.
I mean, I think that's per se just ends the discussion, but even if it doesn't end the discussion, you've got what the trial court What the jury found, which suggests that they were wildly successful in cross-examining and got back to the state of affairs for the jury just didn't think the standard of care was breached, and I urge the court to look at the closings, because in closing, plaintiff's counsel, in response to defense saying Dr. Bird's is a red herring, says they're trying to make Dr. Bird and Dr. Bird's recommendation the central part of our case. That's not true. It's not. Why is it not? Because Dr. Bird said, my note doesn't set the standard of care for surgeons, and admitted it. So that note doesn't even go to the standard of care, which is the thing they lost on in front of the jury. Thank you, Your Honor.
Thank you, counsel.
I remembered what it was. The court had mentioned that the trial court had found that there was attorney misconduct. I just wanted to clarify, the court specifically said it was not making a finding one way or the other on the ruling for sanctions. So I just wanted to clarify that. When Dr. McKinlay gave his deposition testimony,
Let me just follow up on that. You've come up to clarify that the trial court made no finding as to whether there was attorney misconduct.
right, we believe there was. I'm just saying that
But then you'd be asking us to make a new finding on appeal that wasn't made below.
So, let me clarify. The trial court did not was not making a finding whether or not specific ethical rules were violated.
But the court did make a finding of an irregularity.
Yes.
Because of the attorney
Yes.
involvement in the change of story.
Correct. So, just to clarify, there was no specific rule violation. Okay. When Dr. McKinlay gave his deposition testimony and said, I didn't see it because the clinic misfiled it, we immediately amended our complaint to add claims against the clinic for the filing. If he had said, I read it, chose not to follow, we then would have, and then, because the next logical question, as the court pointed out, is, wouldn't Mrs. Winn have a right to know that you weren't going to follow that recommendation?
But then, what do you do with the argument that your original complaint was premised on this, and yet you didn't file an informed consent claim there?
I'm not sure that that has any relevance, because even if we had, that when Dr. McKinlay gave his testimony, that sent us down an entirely different direction, the complete opposite.
But that happens after you file a complaint. I mean, this is what we just heard, is that your complaint is premised on a world in which you could have filed, a factual world in which you could have filed an informed consent claim, and yet you didn't. And so doesn't that suggest that was never really a card you were gonna play at all? I mean, that's the argument that I understood the other side would be making there.
Right, and I guess I would say that the moment Dr. McKinlay gave his testimony, that sealed the deal on an informed consent claim. So even if we had made it, that doesn't mean that we would have shown up at trial and his new testimony, we would have said, oh, this isn't new to us because we made some allegations in our complaint 4 years ago. Dr. McKinlay sent us down the opposite road from informed consent. So I'm not sure.
I take that argument to mean to be important in that you're arguing that in the crucible of trial, we shouldn't be expected to come up with, oh, we ought to be changing tack to informed consent. This has been sprung on us, we're doing the best we can in the moment. We shouldn't bear the burden of coming up with the resolution to the problem. And the point about the original complaint is there was no crucible of trial. There was years of contemplation that could have gone into it. And even when those facts were in front of you with no urgency or all of that, you didn't plead informed consent. So why was it the crucible of trial that means we couldn't think of it? You didn't think of it for years.
Well, we did think of it at trial, and we thought about it in the deposition, but when Dr. McKinlay steered us a different direction, even if we had alleged informed consent in our complaint, based on Dr. McKinlay's testimony in his deposition, and all the other fact witnesses that corroborated the fact that this was misfiled, the jury verdict form would not have had an informed consent claim on it, because there was nothing to support it at that point, because he had sent us down the road of this was misfiled. That's where the negligence was. We wouldn't even have, even if it was in the complaint, he sent us down a different road.
But you had days of trial with opportunities to say, we need a continuance, we need to amend our complaint, we need a mistrial because we've been sent down a different road. And you never said any of those things.
We did not. We did not. In that moment, as the court described as crucible of the trial, we were doing our best with what we were given. And it's neither here nor there, but this was not a strategic decision. not to move for a mistrial. We were doing the best what we had, and our remedies at that point were to try and impeach him. We did the best we could, but that did not ameliorate the prejudice caused by this complete ambush. That everything.
I'm struggling with the suggestion that wouldn't have been a strategic decision. If you learn about the shift in factual approach on day one, and this is a 12-day trial, I'm back to the question I asked Mr. Boer about how much credit do we put in terms of experience of counsel, but it's hard for me to imagine an attorney not going back to the office that night and saying, what do we do with that? And one of the options there would be move for a mistrial. How do we read this record and not think that there was a choice to not move for a mistrial?
Because absolutely, when Dr. McKinlay changed his testimony, we viewed that as we now have someone who we believe is lying on the stand. And we are going to do what we can to work with that.
But one of the available options would be to go to the judge and say, look, this was such a radical shift of factual predicate. We can't fairly try this case, declare a mistrial, and let us come back and do this 8 months from now, and we'll be ready. How's that not a choice to not make that request?
We could have done that. And in hindsight, maybe we could have, but that doesn't mean that we were given a fair trial. Everything that we had done to prepare for that was now gone. And again, this was a calculated plan. And maybe Mrs. Winn's counsel made missteps and made poor choices in that moment, but there was nothing calculated, there was nothing deliberate about how we responded. Rules were violated, statutes were violated, and it deprived Mrs. Winn of a fair trial.
Thank you, counsel. We appreciate both of you, the fine briefing and the arguments here. We'll take the matter under advisement and get an opinion issued as soon as we can. We have another matter scheduled for 10:15. We'll do a brief recess and come back to the bench for that argument.